Good evening, everyone. My name is John Klesch, along with one of my partners at law firm Stitzel, Page & Fletcher. We're very pleased to be here tonight to present a training on open meeting law to Town of Norwich appointed officials. A few preliminary comments before we get into the substance. First thing is everyone should understand that this is a training. This is not an attorney-client session where we're giving you legal advice and answering specific questions about specific matters and how you ought to handle those or what to do, not to do. So keep that in mind. Even though the training is not open to the general public, it is not privileged. So the information is not protected in any way. We are going to have some PowerPoint slides that we're going to use a little bit. For any appointed officials that aren't able to attend tonight, they can contact the town manager's office, and we've heard we'll try to make a set available. The presentation format tonight is going to be, we're going to try not to give just our usual sort of A to Z total cover everything under the open meeting law. There is some fundamental stuff that has to be covered, but and we will cover that in some detail. But we did receive ahead of time a fair number of questions from officials from the town, and we're going to try to focus at least some of the presentation around that. So despite us being on Zoom with a fairly large number of participants, the goal here is to try to make this as interactive as possible. So in order to try to maintain some semblance of order, everybody is muted, and the only way to get unmuted is to use the chat function on your Zoom app there to send a direct chat only to Rod, which is Town of Norwich, I believe is he'll show up as Town of Norwich, and you're trying to select who you want to send the chat to, and you just say, I'd like to ask a question, or will you unmute me, please? And Joe and I are going to take breaks during the course of the presentation to try to let folks weigh in and ask some questions. So with that, we're going to get started. The one thing that I wanted to, so there's the intro stuff we just covered. So one thing before we move on to our information is that we thought it'd be helpful to let you know that Vermont League of Cities and Towns, which of course Town of Norwich is a member, has a lot of great resources, which is one of the reasons we don't want to spend too much time just running through all the statutory overview from beginning to end. So up on the screen here, and this is going to be page 39 of the slides handout, that's the link to where you can get into the open meeting law resources provided by VLCT. You don't have to be a VLCT member to access that stuff. These, when you're on their website, these are hyperlinks. These bottom three, there's top two there are obviously COVID specific. These bottom three are very good fundamental information. So, anybody should feel free to click on and go and have a look over there. So with that, I'm going to stop for a little bit. I'm going to turn it over to Joe McLean, who's going to work on some of the fundamentals that are, definitely relevant to answering some of the questions that we know you all have.
Thanks, John. Thank you for everyone for joining us. As John mentioned, our goal is to really try to answer some Norwich specific questions tonight that have been posed to us. But in order to do that in a way that's meaningful for everyone, we thought that it would make sense to at least have a common understanding about some of the bedrock concepts and principles underlying the open meeting law. And that really starts with the Vermont Constitution. The Vermont Constitution at Chapter 1 is entitled A Declaration of the Rights of the Inhabitants of the State of Vermont. And I can see this PowerPoint scrolling, but the specific language in Article 6 provides that all officers of government are trustees and servants of the people, and at all times in a legal way accountable to them. And this idea that government officials serve the people and ought to be accountable to them is reflected in the language of the open meeting law. And just in case there's anyone out there who's not familiar, what we refer to as the open meeting law is really comprised of 5 statutory sections. I was actually surprised when I looked at it just because a number of them are fairly dense, but there are really only 5 provisions that we're talking about. And they're found in Title I, Chapter 5 of the Vermont Statutes Annotated. And the basic principle that underlies the open meeting law is stated in Section 312A1. And that principle is that all meetings of a public body are by the legislature declared to be open to the public at all times, except as provided in Section 313 of this title. And Section 313, for anyone who's not familiar, is the provision dealing with executive sessions. And the statute goes on to say that no resolution, rule, regulation, appointment, or formal action shall be considered binding except as taken or made at such an open meeting. The statute also notes that a meeting of a public body is subject to the public accommodation requirements that are found in Title IX of the Vermont statutes. The open meeting law is a statute, and the backbone of that statute are certain statutory definitions that really have very specific meanings within the context of the law. And we thought that it would be important to have at least a brief review of some of these definitions. So the first definition, and the one that probably is the most relevant to a lot of what we're going to be discussing here, is the definition of meeting. The open meeting law defines a meeting as a gathering of a quorum of the members of a public body for the purpose of discussing the business of the public body or the purpose of taking action. And that definition is loaded with terms that themselves are defined specifically and are terms of art within the meaning of the open meeting law. So, for example, what is a quorum? Typically, a quorum is a majority of all of the members of a public body, although in certain instances, Vermont law provides that municipal public bodies like the Board of Civil Authority, for example, can operate with a quorum of those present at the meeting as opposed to a quorum of the full board. So it's important to know in evaluating the open meeting law which definition of a quorum applies to your situation. Similarly, the open meeting law talks about a gathering of a quorum. What is a gathering? We typically think of gathering as coming together physically, and for of gathering in terms of physical presence, but the law has evolved.
Hey, Joe. Joe,
now clear that trying to certain statutory requirements.
Yes.
Yes.
You're freezing up. You're freezing up a little bit. I'm not sure what we can do in the short term. Just do you want to back it up a little bit and then just go to the beginning of the definition of gathering?
Yes, I will. I thank you for letting me know. Backing up a little bit, the definition of gathering, as I mentioned, is we generally think of a gathering as a coming together physically. the statute has evolved so that physical presence is not required under the concept of gathering anymore, that a public body can gather electronically or telephonically subject to certain requirements. Let's see. I'm sorry, I have some chats pop up on my screen and I was just distracted by one. The concept of public body, again, also defined in the open meeting law as any board, council, or commission of either the state of Vermont or one or more of its political subdivisions, any agency, authority, or instrumentality of the state or one or more of its public political subdivisions, and importantly for Norwich, any committee of any of the foregoing boards, councils, or commissions. I'd observe, however, that like many statutes, the open meeting law attempts to it attempts to account for government operations at all levels, from the office of the governor, the agency of transportation, down to the most obscure committee in the smallest town in the state. And in trying to account for everything, certain things are sometimes missed. There are certainly questions, open questions in the law. There are ambiguities in the law. One thing that we have recently discussed with Norwich, and that certainly is an issue that we've put some thought into, is what is a committee? The open meeting law doesn't actually define the words committee of a board, council, or commission, and so, or describe how committees are created. So that is an issue that we'll explore further, but it's worth noting that there are some important terms in the statute that the legislature failed to account for. Also, with respect to committees, I would note that at least in a land use planning context, there are specific statutory provisions, not in the open meeting law, but in Title 24, Chapter 117, specifically 24 VSA 4433, contains specific provisions for a municipality to create committees to assist, and I don't have the language in front of me at the moment, but essentially to assist with advising the select board or planning commission with respect to town plan functions. I'll also note that there is language in the rules of procedure for the Norwich Planning Commission regarding the creation of committees. So that may be worth taking a look at some point. But back to the open meeting law, again, it's important to note that the open meeting law doesn't apply to every gathering of a quorum of the members of a public body. The gathering has to be for the purpose of either discussing the business of the public body or taking action. And generally speaking, when the statute refers to action, they're not talking about physical action. They're talking about voting. So when the statute refers to taking action or acting, it's primarily referring to a vote of the public body. Finally, the business of the public body is statutorily defined, and the statute provides that a public body's governmental functions, the business of the public body include the public body's governmental functions, including any matter over which the public body has supervision, control, jurisdiction, advisory power, etc. So those are the sort of the fundamental definitions that control a lot of how the open meeting law functions in any particular situation and how it ought to be interpreted and applied. Interestingly, the open meeting law also goes to significant length to tell us expressly what is not a meeting. So in the definition section of meeting, the statute also says that a meeting is not communications, whether in person, by email, by phone, between members of a public body for certain specific purposes, such as scheduling a meeting, organizing an agenda, distributing materials to discuss at a meeting, provided that, and you'll hear that phrase a lot in the open meeting law as well. There's a rule, then there's an exception, and then there's a proviso that is added to the exception. So here, the provided that is no other business of the public body can be discussed in connection with these communications, and any written communications that are developed for the purposes of scheduling or organizing or distributing materials need to be preserved and available for inspection and copying under the Public Records Act. So that's number one of what is not a meeting. There are also occasions, and perhaps it's probably likely that a number of Norwich boards and commissions have experienced this, where a quorum of a public body will gather for some social gathering or convention or conference or training similar to this, media events, press conferences. The statute also states or otherwise gathers. So that's a non-exclusive list of other instances in which a quorum can get together and gather without triggering open meeting law requirements. Again, provided that the public body doesn't discuss its business, particularly where that business is expected to be taken up by the public body at some later point in time. A further exclusion from the definition of meeting is that a gathering of a quorum of a public body can attend a meeting of another public body, provided that the attending public body takes no action, in other words, doesn't vote on any of its business in connection with the meeting that it is attending. The open meeting law also specifically states that it doesn't apply to the judiciary, it doesn't apply to the Public Utility Commission, and importantly, particularly for DRB or select board proceedings, it doesn't apply to deliberations of a public body in connection with a quasi-judicial proceeding.
Joe?
Yes.
Can I suggest before you, if you were going to, at this point, go in some depth in quasi-judicial, I was thinking it might make sense to pause that part of the presentation, go back to some of the questions we have that are more on some of the other fundamentals you already reviewed, and then pick back up after looking at those with the issue around, because there are also some specific questions we got around quasi-judicial and deliberation matters.
Yes.
I don't know, I'm sorry if I cut you too soon, but.
Nope, you just cut me 1 second too soon, which was that just to note that the open meeting law also does not, specifically does not apply to proceedings, records, or acts that are made confidential by law. But, you know, with that said, I think this would be a good time to pause and see if there are questions about what we've discussed.
Okay, well, before we do that, let's go take a look at some of the questions that we had received from folks ahead of the meeting. So got a couple slides where we tried to consolidate some of those questions, and I'll take a swing at answering a few of them. And then I think at that point, just so folks are aware, that's when we're planning to have our first round of opening it up for participants to participate. So hold on one second here. All right, so here's, so we, like I said, we received some questions. We sort of tried to distill them down a little bit. And here's what some of the questions we saw. What happens when the historical commission or a consultant wants to meet with a property owner regarding a grant application? What happens if the rec department wants to meet with parents or students around planning an event? What happens when some members of a board, but less than a quorum, want to meet via Zoom to discuss an issue prior to discussion with the full board? And then what happens where you've got a single board member who wants to do some work on drafting a document that may end up getting taken up by the full board for adoption? So, you know, the presentation Joe gave, really it's all about deploying those definitions is how you go about answering these questions. And so for the first bullet, you know, if it's a quorum of the historical commission is meeting to do those things, then you've got an open meeting situation. You've got to deal with the open meeting law and comply with it. If you've got less than a quorum, then the open meeting law doesn't apply. And by the way, of course, if the commission is going to meet with somebody outside of their regular meeting schedule, it's got to be warned as a special meeting, which has to have both, has to warn of time, place, and purpose at least 24 hours in advance. And there's some other requirements, prerequisites to how you go about warning that. In terms of the recreation department, well, the recreation department doesn't meet the definition of a public body because it's not a board, commission, committee, or what's the other one, Joe, I'm missing?
Council.
Council of the municipality. So town departments, town employees, they are not subject to the open meeting law. Now, of course, if they come to present things to the select board or the planning commission or whatever, then you've got a different situation. They're going to be doing that in the context of an open meeting. But just for the sake of doing their day-to-day work, including meeting with people, the public, and so on, not subject to the open meeting law. The third item was what happens if less than a quorum of a board wants to meet via Zoom to discuss an issue. Once again, the open meeting law does not govern that situation. Now you might say, well, wait a minute, isn't that a loophole to the requirement that the open meeting law's requirement that the business of the public body must be conducted in an open meeting, because the business of the public body is defined to include governmental functions, any matter over which the public body has supervision, control, jurisdiction, etc. So any discussion of the business of a public body is subject to a meeting. But again, the whole prerequisite you have to put in front of all of that is quorum. So if you don't have quorum, you're not violating the open meeting law for two select board members, say of a 5-member board, for example, to get together on Zoom and actually discuss the business of the town. Where the open meeting law makes sure that the public does have a right to observe, possibly participate to some extent, and so on, just be aware of what's going on, is that nothing can happen with that 2-member discussion unless and until the subject matter makes its way to a full board meeting at some point. Because obviously, as you all know, 2 members of a 5-member board have no authority or power to do anything for the most part. I mean, there's an exception that a select board or a city council can grant 1 member the authority to draw orders off the treasury. Got a vote to do that, but otherwise there's almost no situation where there's actual authority to make decisions or take actions that belong within the authority of the full board.
And I would,
so
I'm sorry, John, I would just add to that, again, coming back to this concept of committees, there's not a significant legal question that the open meeting law applies to committees of a board, council, or commission. But again, in order for, and it's conceivable that a quorum of a committee might be subject to the open meeting law, but in order for that to occur, there would need to be, in our view, some formal designation of the committee and delegation of authority to the committee. Absent that, though, for example, take the let me see if there's
We had some committee examples on the next slide.
yeah, they're the next slide. Okay.
Yeah.
There we go.
Go ahead,
Sorry,
yeah.
I jumped ahead of you.
No, go ahead. Do you want to keep going? I can take it from here. It's up to you.
Go ahead.
Just so, yeah, so we covered those other basics. So yeah, committees, just again, backing up what Joe says, basically trying to figure out how do you define a committee, and there's really not clear Vermont, the statute doesn't define it, nor is there any really clear case law that we know of at this point that really gets into saying what is and isn't. But basically, if it's something that's been sanctioned by a recognized body, so if a board, commission, council says, we're voting to form a committee, okay, you've definitely got a committee. If 2 or 3, well, 3 is a bad example, but 2 members of a 5-member board take it on themselves to go start working on something with the idea that they're going to bring it back to the board at some point. I mean, that's not a committee, because in our view, that's not a committee, because in that situation, the parent board, if you want to call it that, hasn't actually done anything to designate that group to be a committee. So we got some questions about, well, what do we do in these situations where a committee might be involved? So we understand there's a trails committee, and it may be a 3-member committee, and so it may not take much for a quorum to get together, right? Two members might say that they're going to go out and work on bushwhacking down some weeds on a rec path or something like that. Well, even though that's taking action of a sort, we don't believe that that is taking action within the meaning of the open meeting law. The taking action within the open meeting law means passing a resolution, voting on something. Again, the definitions Joe already ran through, and the language is right there in the statute. And if folks are going out and executing on things that have already been decided, our view is that the executing is not taking the action. The action was already the thing taken that said, yeah, you guys have authority to go and work on that trail whenever you want.
With that said, it's correct that, in our opinion, operating the chainsaws or dragging the rake on the trail is not action within the meaning of the statute. But while you're out there, if you're on the Trails Committee with a quorum of the committee members, while you're out there raking and sawing, you should be scrupulously avoiding substantive discussion of the business of the Trails Committee. Particularly, I mean, that's not to say you can't say, pass me that bar lube, but what you should be avoiding is planning future work assignments, talking about other aspects of the Trails Committee charge that is beyond the scope of the particular work assignment that you're sort of on the ground to do that day. Larger concepts that require planning or consent of others ought to be brought back to the full committee or the Conservation Commission for further discussion at an open meeting.
Yeah, look at it. One way to look at it is this, and this is not necessarily going to solve every situation, but if you've got a quorum and you think you want to talk to your quorum mate about something that, if it's going to lead anywhere, is going to require a vote of the public body, then you're probably going out of bounds to talk about it with a quorum outside of a meeting. So, I mean, that's a shorthand way to think about it. Is this something that we would vote on at some point in time in order to actually do something about this idea or this issue that we have?
And John, if you wouldn't mind, this might be a good place to just jump back in with a couple of more open meeting law does not apply examples. The reason that these examples are a little bit disjointed is that's the way the statute evolved. But in addition to statutory, so if you're reading the statute, and again, it's only 5 provisions, and I would encourage everyone to go to the Vermont statutes annotated online and take some time to read this language. Some of it's fairly dense, but I think familiarity is important. But when you do that, you will see that not only are there definitions that exclude certain things from being a meeting or from operation of the open meeting law, but there are also some substantive statutory provisions that do the same. And so if you're looking at the statute in section 312G, you'll see that the open meeting law, in addition to deliberations, which we're going to talk about more in a moment, also specifically states that site inspections for the purpose of assessing damage or making tax assessments or abatements are not subject to the open meeting law, nor is clerical work. This is an important one. Work assignments of staff or other personnel, which we believe may include any number of municipal volunteer positions, and routine day-to-day administrative matters that do not require action, again, voting, by the public body, and provided that no money is appropriated, expended, or encumbered in the process. It's important to note that the legislature didn't intend that routine day-to-day work by the municipality would be unreasonably hindered by open meeting law requirements. You know, the goal is to safeguard public access to and notice of, and with certain limitations, participation rights in the public process and in discussions regarding public business and in votes to take action. It's not to interpret the open meeting law in a way that sort of unreasonably impedes sort of the daily work of municipal officials. So there's a balancing that goes on. You can see it in the statute. You see it when you go to court and you talk to a judge about this stuff. And the balancing is, you know, it's balancing rights and limits, with the idea being that rights are liberally construed. But a good example of this is right in the language of the statute that talks about the opportunities available to the public to comment during an open meeting. And the statute says that at an open meeting, the public will be given a reasonable opportunity to express its opinion on matters considered by the public body during the meeting, as long as order is maintained. Public comment is subject to reasonable rules established by the chair, and that right of public comment does not apply to quasi-judicial proceedings. So if you're in a, if you're a member of the audience at a DRB hearing on a conditional use application and you're not an interested person or party to the application, you don't have a right to comment. Although I have personally seen that some boards will give open the floor up for general comments on applications. But you know, with that said, I think the fact that the legislature makes an attempt to balance reasonable opportunity with reasonable rules is reflective of a lot of how the statute operates or ought to operate when it's given a proper interpretation.
Jeff, let me just make sure we got one more piece on the committees, and I think that dovetails into it, covered. And because this was a question that some people, we gave the Trails Committee, chainsaw, brush clearing example, but some of the other questions we saw had to do with, what if a committee is charged with gathering information and bringing back, some kind of report, etc. Well, again, similar to the chainsaw example, again, if there's already been a decision made that a committee is going to go out and gather information. So let's say, for example, you have Historic Preservation Commission, and they're going out taking a survey in town of how many residential properties have picket fences on them. And they all go out together, and there's a quorum of them walking through the neighborhood, and they're taking down data and taking photographs. Again, it sounds like they're quote unquote taking action, but the authorization to do that or the later coming vote, something having to do with the information, that's the action. So again, in our view, that kind of thing is not subject to the open meeting law. And drafting documents was another one that came up, and there's different contexts for that. And again, we're going to have to go back into the quasi-judicial stuff to answer that in part. But again, it depends. If you got less than a quorum and you're drafting documents, you're fine. So 2 members of a 5-member board can get together, work on a document that they intend to present to the full board at some point for consideration. But if you have a quorum of a board working together on drafting documents, that's where we believe that you may not be taking action necessarily, but it's probably likely in our view that you are discussing the business of the public body. I mean, if you're working with somebody on a draft document and it concerns the matters that are before or going to be before the commission or the board or the council, that seems to us to be a quorum discussing the business of the public body. And so we do think that that kind of scenario is subject to the open meeting law. There might be plenty of reasons that that meeting could be subject to an executive session, but the threshold question is whether it's subject to the open meeting law. So before we get back into the body of the presentation, now would be a good time if people have questions based on what we've gone through so far. Rod, is there anybody in the queue who wants to ask any questions at this point?
Yeah, I've got a bunch of questions in the chat box, I guess, and some of those I think have already been answered. So I guess I have, I'll go through some of the really quick points. So Alex, the Fire Chief Alex Northern asked whether there's going to be a copy of this PowerPoint. And Alex, we explained at the beginning that members of boards and commissions who can't make it tonight should get in touch with the town manager for a copy of the material presented tonight, but it's not ready right now. And then there was a question about the Board of Civil Authority. So if Jonathan Teller-Ellsberg is present, I'll unmute you and you can ask it, or if you're happy for me to read your question, I'm also happy to do that. So let me unmute. Well, I say this. Hang on a second. Why don't I just read the question? So this is from Jonathan Teller-Ellsberg from the BCA. It references a comment made from Joe. Joe said that a quorum of the BCA consists of any number of the BCA present. It's one of those boards and commissions in Vermont where it's not a majority of the number of positions, it's the number of people present. One activity the BCA sometimes has to do as part of dealing with tax appeals is visit a property in question. When our BCA has done that in the past, we usually send 3 members of the BCA to conduct the inspection. Is that inspection a quorum and subject to open meeting law? That's the question.
I'm sorry, did you say how many total members are in the BCA?
I actually don't know the answer to that question. Maybe.
Well, it may not be relevant because the statute, as I mentioned earlier, the section 312G of the statute specifically states that this subchapter shall not apply to site inspections for the purpose of assessing damage or making tax assessments or abatements.
Right.
So my quick answer, based on just on the language of the statute, is that those types of site inspections by the BCA members are exempt from the open meeting law. I would, if I were looking at this in more detail, I would also review Title 32. I think it's 4404, but I could be mistaken, just to ensure that there's nothing there. But my initial response would be not subject to the open meeting law.
Yeah, okay, great. I have a question from John Carroll from the Development Review Board. His question is a question about voting with a bare quorum. So you've just achieved quorum, you don't have a full complement of board members. Does the vote then have to be unanimous to carry forward action, or can it be a majority of the bare quorum? In other words, say the quorum is 4, and you are normally comprised of, I don't know what it is, 7, and 2 people are for something and 2 people are against. Does the action carry, or does it fail?
Fails.
Fails.
And that would be true if it was 3-1.
Right. Okay. So.
And that's not in the open meeting law, right, Joe? That's in
1 VSA 172, which is the provision that defines joint authority and requires that where joint authority is given to 3 or more, that a majority of the members, this is not the language of the statute, I'm paraphrasing, but must affirmatively vote in order to take action.
Right, right. That's definitely my understanding with DRBs, that if there's a less than full quorum present to carry a decision to issue a permit, it needs to be a.
Right. And it can get tricky. There is a case out of Burlington involving the Burlington Planning Commission, where I believe the city of Burlington had adopted Planning Commission rules that allowed for action by, or I should say approval, since we're saying action is the vote, but it basically provided for the ability to approve on the basis of a quorum of those present. And ultimately the Supreme Court said no. The statute requires a majority of the Planning Commission or a majority of the board involved.
Okay, that's great. Thank you very much.
Herb, should we try to get one more in before moving?
Yeah, let's just do one more. So, if you were to ask, if you're on a board and you ask volunteers to work on an issue, so if you simply seek participation from some members of the board, you don't specify how many or what they're doing, and 2 people volunteer, are they now automatically regarded as a committee and therefore have to warn any conversations between them, or are they just 2 volunteers?
My reaction to that would be if this is just thinking out loud, so I'm not saying this is 100% correct and we need to hear what Joe says. My reaction to that would be if you've got a 5-member board and they're sort of saying, we should get some information on how we're going to, approach this or whatever. And Herb and Rod say, well, I'm willing to spend some time on it. And Rod says, yeah, me too. And the board says, okay, let us know what you find and come on back. I'm skeptical of that being a committee myself, because, the board hasn't expressly voted something, and that's how boards do things. You pass motions. and that's an action, right? So, you know, without a formal vote, I'm skeptical that that's a committee. I'm not telling you that's 100% correct, and it probably has something, it may also have something to do with what exactly is the nature of the work. You know, how close is the nature of the work to the kind of thing that would go on at the board meeting versus the kind of thing that's outside the board meeting and maybe closer to, you know, what Joe was describing there in 3112E, when it talks about, oh, not 312E, I'm sorry, 312G. Yeah, when it's talking about, you know, work assignments of staff or other personnel. Now, obviously, the board members, commission members are not staff or personnel, but if they're out there doing some of that kind of work to bring it back to the board, again, I'm skeptical that you formed a committee in that situation. Joe, what do you think?
I mean, I am also inclined to believe that to properly form a committee, there should be a delegation of authority and a charge, a committee charge that is specifically defined so that the scope of that authority can be understood. And I think that's typically done by vote. It is conceivable that now, you know, I read 312G's language regarding work assignments of staff or other personnel to potentially cover instances in which members of a public body and not less than a quorum volunteer for some work assignment. But you know, it's a question that is not clearly addressed in Vermont law. Like many questions, you know, we're a small state, and unfortunately, while we're starting to make more law, you know, there are a limited number of open meeting law cases out there to draw from. So precisely how the open meeting law applies to committees is not known. We know that it does apply to committees, but again, it's really a question of what is a committee, how is a committee formed, how is a committee distinguished from volunteers undertaking a work assignment or other, you know, day-to-day administrative matters. And
if I could just chip in, I mean, again, put it this way. We're not aware of any court decision that says less than a quorum of a board doing something having to do with what that board does is a meeting. So obviously, if you cross the threshold into a quorum, totally different story. It doesn't, you know, there's no way around the open meeting law when you've got a quorum working on something. When you've got less than a quorum of the body, okay, it's not an open meeting law an open meeting of the body. The question is that a committee? And again, we just don't have any clear case law saying that anytime there's more than one person doing something, it's a committee. That doesn't mean that's the end of the question. And you know, you could be ultra conservative. Ultra is not the right word. You could be conservative in your practices, and you know, you could warn, I suppose, if you've got two members of a 5-member board doing something and no one's used the word committee and no one said the board is officially, you know, sanctioning them to do some work and bring that work back to the board. But I suppose if there's concern that one of these days someone is going to challenge that and say that that's some kind of open meeting law violation, I don't see why you can't go through the warning process if you want to. Suppose your 2-member team is having a special meeting and you're going to warn it. And to me, the fact that you warned it doesn't really prove you're a committee or not. It just means you've told the public you're working on something, whether you had to or not. Okay, so let's get back into the, Joe, you're going to talk about what is a deliberative, what is deliberation and what is quasi-judicial?
Yes. Yes. And
should we do the quasi first or deliberation first?
well, let's do deliberations first, and then we can talk about quasi-judicial. As I mentioned, the statute specifically exempts from operation of the open meeting law the deliberations of any public body in connection with a quasi-judicial proceeding. And again, the term deliberations is defined in the statute as the weighing, examining, and discussing of the reasons for and against an act or decision, but expressly excluding the taking of evidence and arguments of the parties. So we know deliberations are not taking evidence. Deliberations are not argument. And deliberations by definition, because they're not meetings, are exempt from the open meeting law. There's no notice of a gathering that's required. Deliberations can be conducted by email or phone. There's no formal process or procedure. There are no minutes taken. When I work with quasi-judicial public bodies in the conduct of a quasi-judicial proceeding, and they get to the point in which they're ready to deliberate, I usually advise them that deliberations can occur in any reasonable manner at any reasonable time and place. But it's important to remember that not all they have quasi-judicial proceeding, and obviously, can you still hear me okay, Rod?
Yeah,
I'm getting a notice.
You just broke up a little bit.
Getting a notice my connection's unstable.
Yeah,
but just to continue, the deliberations have to be in connection with a quasi-judicial proceeding, and quasi-judicial is also a term that is defined in the statute. A quasi-judicial proceeding is one that is either a contested case under the Administrative Procedures Act, or a case in which the legal rights of one or more persons are granted party who are granted party status are adjudicated. The parties have an opportunity to present evidence. They have a right of cross-examination, and ultimately, a written decision is issued that is appealable. So obvious examples of this are DRB hearings on conditional use applications or variances, select board hearings related to curb cuts or access permits, and BCA hearings on appeals from decisions of the listers would be typical quasi-judicial proceedings. It's important to note that the statute does contain specific provision for public bodies rendering decisions in a quasi-judicial proceeding to issue those decisions without adopting them at an open meeting if the decision itself will be a public record. So the specific language of the statute states that a written decision issued by a public body in connection with a quasi-judicial proceeding need not be adopted in an open meeting if the decision will be a public record. What that means is that after deliberating, the public body doesn't need to come back into the open meeting from deliberations to announce its decision. If the decision is going to be in writing, it can just issue the written decision. Another thing I just want to note about deliberations, and this is just a point that I often try to make when we talk about open meeting law, is I try to discourage the use of the term deliberative session. And the reason for that, and I greatly prefer just calling them deliberations. And the reason is that deliberative session is easily confused with executive session. An executive session is something very different from a deliberative session or from deliberations. And the former is deliberations are exempt from the open meeting law. They are not a meeting at all. Well, executive sessions are essentially a conditional exception to the general requirement that meetings be open at all times. And it's important to try to understand the distinction between those two concepts, because you can do in deliberations, if you're properly deliberating, things that would never be permitted in an executive session. That's just something to keep in mind.
So can I add a few comments on this?
Yeah, go ahead. Please do.
So there's a couple things that are worth just making sure we're clear on. So one of the things for quasi-judicial proceedings is contested case under Vermont Administrative Procedures Act. One thing that can get confusing is don't confuse the Vermont Administrative Procedures Act with the Vermont Municipal Administrative Procedures Act. And the Municipal Administrative Procedures Act does have, sort of procedural due process built into it. It actually parrots a lot of the rest of this section of the definition of quasi-judicial proceeding in 1 VSA 310, which is in the open meeting law. But what's interesting about that is a municipal public body does not need to formally adopt the Municipal Administrative Procedure Act in order to have something be a quasi-judicial proceeding. People get mixed up on that sometimes. You don't even need to formally adopt the Municipal Administrative Procedure Act to follow it. It's good guidance on how to conduct a quasi-judicial proceeding, even if you don't formally vote to follow it. Because once you formally vote to follow it, then you're at the peril of screwing it up and not doing what the Municipal Administrative Procedure Act says. Another interesting thing about quasi-judicial proceedings is don't confuse the fact that because deliberations are not subject to the open meeting law, that the actual hearing is somehow automatically subject to executive session or the like. That is going to depend entirely on the subject matter of what the proceeding is. So, for example, if you are having let's say a municipal employee gets terminated and you're having a post-termination hearing with, actual evidence and parties having the chance for representation and creating a record if that's the way the situation calls for, if the policy that calls for that. That is probably subject to an executive session because the board is considering disciplinary action of a municipal employee, which is a grounds for executive session. But that's not going to be the case every time, of course, right? So like a town highway discontinuance proceeding, which the Vermont Supreme Court says is quasi-judicial, there's going to be almost no way you can get those into executive session. So your hearing is going to be out in open session, but then you'll deliberate. And of course, very key thing to keep track of, we can't emphasize this enough, and when you're deliberating, that's all you're allowed to do in that session. It's a very narrow carve out from the open meeting law. My example about an employee, right? You're looking at a disciplinary action of an employee. You can't talk about other things having to do with say you're looking at disciplining somebody who works in the Parks and Rec. You're not able to talk about the structure of the department or whether the manager has done a good job with that employee. You have to focus on what is the evidence that came into the hearing and what result does the evidence call for. So those are a couple of bugaboos that just to be mindful of. Now, I know we actually had some deliberation questions received, so I'm going to hop down to those real quick. Yeah, so let's see. What exactly are deliberative sessions? Well, as Joe said, cross out the word sessions and just call them deliberations. By the way, you can deliberate in a meeting, right? I mean, it's not like there's some prohibition to deliberating, but again, you're going to have to look at whether the subject matter does or doesn't qualify for executive session unless you want to deliberate in open session. The question is, can deliberations be on a different day than the hearing? Absolutely. You know, you have to watch yourself that a lot of quasi-judicial matters have a decision deadline. But other than that, once the hearing record is closed, you're free to deliberate whenever, however, wherever you want, you know, as is reasonable. Including, you know, here's another question, can we do it remotely by email? Absolutely, absolutely. Members can email one another all they like about deliberations. Are there Public Record Act implications for that? Well, maybe. There is a Public Record Act exemption for records of a body's quasi-judicial deliberations, which normally should apply. 317C24, I think it is. But, you know, be mindful of the fact that whenever a public record is created, the burden is going to be on the public body to demonstrate that an exemption applies. So, I mean, you can't just automatically assume, you need to be thoughtful about it. I already hit on this issue, what are permissible subjects, right? It's got to be what is the subject matter of the hearing. You know, again, you're having a hearing, let's say, on whether to uphold a discipline of a Park and Rec employee. You can't have a broad discussion about the Park and Rec department funding or events or how the director of the department's doing. You've got to really stick to it. We got asked, what are best practices? You know, I guess the question is, how do you go about deliberating? And I'll be curious to hear what Joe has to say on that. But, you know, in my experience, it really depends on the board. Different boards function differently. So, you know, I've worked in the capacity serving as board counsel to school boards a lot of times who were dealing with discipline or termination of a teacher or an administrator. And, you know, they are not people who crank out decisions on a regular basis, right? They're not, for a school board serving in a quasi-judicial capacity is not the norm. Whereas for a DRB or a ZBA, they work in quasi-judicial capacity all the time. And in fact, they have staff, and that's one of the questions, right? Staff is probably very often involved in those. And yeah, it's completely within their discretion to say, we're going to ask staff to work on this draft decision and bring it back to us, and we'll look at it. And again, none of that is subject to open meeting law oversight, as long as you're within the rules and you know, you've got legitimate quasi-judicial subject matter. And then, you know, what do you do with circulating drafts? Can you do it by email? Can people comment, vote, edit? Yes to all of that. That's all perfectly fair game. I mean, basically, think of it this way. Once you've crossed into the quasi-judicial territory, you're basically like a court, and you're like an appellate court, right? A trial court usually just has one judge. An appellate court has 3 or 5 or 9 or whatever. And so, you know, how would those folks go about working on a decision? They'd exchange drafts, they'd exchange ideas, they'd meet, they'd talk, and that's all the kind of stuff you can do. Now,
they might assign the first draft of the decision to their clerk.
Yeah, absolutely.
Right?
And listen, even if the subject matter of a quasi-judicial hearing is not technically confidential, you know, our advice is almost always going to be to behave in a confidential manner around deliberations. You know, there's a reason that it's outside the open meeting law. In fact, deliberations is a common law privilege, exists for public body deliberations. That's another Public Records Act recognized exemption. And so, you know, okay, if you're deliberating like on a town highway issue, it's probably less sensitive, but when you're deliberating things about, you know, employees or things of that nature, you know, we recommend that you ought to, for the most part, treat it confidentially, assume that until the board gets to a point where there's a consensus majority on getting ready to sign a decision and issue it, that it's confidential. And by the way, one question we get asked sometimes is about signing the actual decision. Again, Joe, correct me if I'm wrong, the 1 VSA states that a chair of a board has authority to sign a decision, right, on behalf of the board.
I believe it's in Title 24, but that's correct. The chair or vice chair alone can sign the decision.
Yeah, so it's, you know, a lot of times it's a matter of sort of showing solidarity of the board, you know, that y'all want to put your signatures on something and stand by a decision you've made. So is that a best practice? You know, does the situation suggest that that's a good idea? I mean, I guess that's would be my answer to that.
Yeah, one thing I would add, specifically in connection with the best practices for the DRB is, as I'm sure many people are aware, the zoning administrator, I believe in Norwich, it's very common in many towns around the state for the zoning administrator to staff the DRB. But as a matter of practice and as a best practice, it's important in deliberations to be mindful of the matter that is before the DRB. And obviously, the DRB hears appeals from decisions of the zoning administrator. The DRB also has to render decisions in enforcement actions that may be commenced by a notice of violation issued by the zoning administrator. So even though the zoning administrator serves as staff for the DRB, there may be instances in which it would not be appropriate to invite the zoning administrator to participate in the deliberation, particularly where you're not, in those instances where you're not evaluating an application against the standards in the zoning bylaws, but instead trying to determine whether or not the zoning administrator made a correct determination in finding that a violation exists or in denying a permit that is then appealed to the DRB.
Yeah, I mean, in those contexts, the ZA is almost like a party to that issue.
Yeah, I mean, I don't look at it as true party status, but at least that they are presenting the position of the municipal official involved.
Yep. Rod, do we have some more questions that would be appropriate to discuss now? We can't hear you, Rod.
We've had some comments, but generally there are no questions that I can see with the material that you've just covered. So I think now is a good time to go on. I guess the one question from a little bit earlier that we didn't cover was if the Board of Listers would want to develop an RFP for conducting a reappraisal, are committees or commissions allowed to hold working sessions, I've got in inverted commas, where they are working on an issue, such as an RFP, without violating the open meeting law? Is this administrative work? That's, I guess, so the key question there is having a work session regarded as administrative work?
I would say not necessarily. First of all, if you're talking about a quorum, then you're in very dangerous territory. So probably do that kind of work outside of an open meeting. You know, preparing an RFP, if it's going to have anything substantive in it, and this is just me reacting off the cuff, if there's substance in that document, if someone's got to think about what this thing should say, then I don't see how that isn't in the realm of substance and policy versus purely, you know, administrative or clerical. That's my reaction to it. Joe, what do you think?
Well, again, I think it depends on whether you're talking about a quorum or a non-quorum type of situation. And then, you know, like many things, it's highly fact dependent. You know, we mentioned the fact that clerical work assignments, day-to-day administrative matters are generally exempt from open meeting law requirements, but of course the statute doesn't define what any of those terms mean. And so you really need to look carefully at what it is, what is the involved work. As John mentioned, you know, does it involve any type of substantive policy determination? If so, or is it just routine? I mean, there are instances where the listers might get together to just maintain the grand list. They're really not doing anything substantive. That may be that might be the type of thing that would be viewed as day-to-day administrative work. But I'm reluctant to broad brush too much of this, because every situation is a little bit different and needs to be examined on its facts. But I wouldn't assume, simply as John said, I wouldn't assume just because you don't have a quorum present that you're automatically safe.
Okay. And then I think Herb made a follow-up remark, which is that because ultimately the RFP, if it was to be released and circulated, you're encumbering town funds. So at some point, the process of discussing the contents of the RFP and the process that goes with it would need to be discussed in an open meeting law sanctioned meeting, because of the question of the obligation of public funds.
Now, are we talking, just to be clear, are we talking, the Board of Listers has 3 members? How many members?
I'm not sure.
3 members, Herb says. Okay. And so if we're talking about scheduling a work session with all 3 members, or even 2 members of the listers, it's really going to involve having to drill down on what exactly it is that they're doing.
Okay. So they should proceed with extreme caution then.
If you have a gathering of a quorum, and there is a potential that you're going to be discussing the business of the public body, I mean, put aside for a moment the fact that presumably no vote is going to occur.
Right.
It's conceivable that you have a meeting. It's also conceivable that, depending on the specific nature of the work, that it might be characterized as clerical or administrative or sort of a routine work assignment, in which case, it may not ultimately fall within the bounds of requiring compliance with the open meeting law.
Hey, Joe, would now be a good time to shift gears and talk about something? I'm not even recalling if it's in the outline or not, but this is a question that comes up a lot. The disconnect between the definition of gathering in the open meeting law versus our concern about members' quorum or like, playing telephone by email and talking about issues that are the business of the public body by email.
Right. I'm glad you brought that up, because I was also thinking about that as something that we should have mentioned when we were talking about gathering electronically. It is in some communities, on some occasions, we've seen instances in which there's an attempt to use serial communications to sort of avoid a gathering, and sometimes that it works and sometimes it doesn't. But I think it's cause for it's potentially cause for concern. First of all, anytime that there is an intentional or willful attempt to avoid obligations under the open meeting law, I think if you ultimately end up in court, the judge is going to look, much more skeptically at what occurred. But in terms of email communications, we have looked at whether or not the communications are contemporaneous, and it's, with technology these days, it's possible to be in 5 different places and have virtually instantaneous communication through reply all messaging. And there are court decisions out there that do look at this type of communication and say, that was a meeting. And so it's definitely cause for concern, and you need to be mindful that You try to avoid, I mean, as I mentioned earlier, you can use email for certain things, to pass along certain information, to schedule meetings, but you really need to be scrupulous about avoiding substantive discussion. And it's tempting. You know, an application comes in to the DRB, the zoning administrator pushes it out. It's for a project that's controversial or exciting. And the initial email is just, you know, looking to schedule a hearing. Get back to me with your availability. Sent to everyone. It can be tempting sometimes not to weigh in with some type of substantive thought on the application, but you know that it can be a risky proposition if you're talking about trying to ensure open meeting law compliance.
And Joe, am I correct in remembering that I don't know of a Vermont, certainly not a Vermont Supreme Court decision on point where they've looked at exactly this scenario of when does a quorum of a board communicating with one another by email become a meeting, you know, that happened without a warning. But we just think it's a matter of time, you know, before that is the way a court is, like the Vermont Supreme Court would be likely to go on this, notwithstanding that possibly you can make a hyper-technical argument around it based on the specific text of the statute. Yeah, what about, Joe, when a board member wants to send someone out to the rest of the board and say, this is something I think we should look at or talk about at an upcoming meeting, and it's got some substance and says, you know, this is an issue in the town and we should take a look at this. Do we think that's okay, or do we think that's a problem, or is it too fact dependent to generalize on it?
Yeah, I would want to know what it was that they wanted to look at. But in generally speaking, you know, I think you can push out at our next meeting. You know, I'd really like to discuss adopting a leash law ordinance. I think identifying the subject of what you want to talk about is fine, but then going on to say, you know, there are dogs running up and down my street every day, and you know, this is a problem we really need to get under control, et cetera, goes too far.
I agree. Okay, so if there's no pending questions, Joe, let's see, are we back to the outline? Do we have more to cover in the outline? What's a meeting? Oh, do we want to quickly touch on that issue you and I were discussing about today about how public comment has to happen? I can take it real quickly.
Yeah, sure, go ahead.
So the statute says that at every meeting of the body, the public shall have a reasonable opportunity to comment. But it doesn't say exactly what that has to look like. And we've seen a couple different versions of it. We've seen some boards has like a general public comment session at the beginning of the meeting where it's just kind of open season and they'll let anybody bring up anything they want. You know, so if someone says, hey, I think we need a new swing set at the playground. And so, you know, stuff like that, whether it's on the agenda or not, you don't have to do that, because what the statute talks about is an opportunity to comment on, let's see if I get the exact language here. Opportunity to express its opinion on matters considered by the public body during the meeting, as long as order is maintained. That's 312H. So that's the exact requirement. So if something's on the agenda, you have to find a way to let the public have a reasonable chance to comment on it. And we've seen it done three different ways, I guess. One is have it at the beginning of the meeting. Say you've all seen the agenda. There might be amendments to the agenda. You've heard those amendments now. If anyone has anything they want to say about what we're going to take up tonight, now's your chance to comment. Another way to do it is as you move through the agenda, ask for comment at each step of the way. Some folks might say that is more in tune with what the legislator might have intended. But, you know, the counterpoint to that, I would say, is that, you know, remember that this is your board meeting or your council meeting or your committee meeting. This is not town meeting. This is not an open hearing to the public unless you happen to have a hearing as part of your meeting agenda. So, you know, there is some flexibility there. And again, the chair is always, you always have the rule that it's subject to reasonable order being maintained. So if you don't think reasonable order is consistent with this concept of people chiming in as the meeting goes along, you know, that's up to you. Sometimes when you have a very hot matter with lots of public comment, you know, that reasonable rules and order means that you are going to set time limits. And maybe you're going to say, you know, after an hour, we're going to stop this for tonight. We're going to have to continue it to a next meeting or something. But the one thing that may probably not work, I would say, for the open meeting law, in my opinion, I don't know there's a court case that says this, but is saying, okay, you've seen the agenda. We're going to give you a chance to comment, but we're going to give you a chance to comment as the last thing before we adjourn. Because then the public hasn't had a comment opportunity before you've taken possibly action on the item or considered the item. So it seems kind of meaningless, right? If you say we're going to move through the agenda, we're going to vote a bunch of stuff out, and then the last thing of the night is we're going to have an open comment session, and someone's going to say, yeah, that thing you did back on item number 3 on the agenda, I'm really against that. Well, you've already voted it through. So probably questionable there whether that actually meets what the open meeting law is expecting of you.
And if I could just say a couple of things about agendas. The open meeting law contains specific requirements for electronically and physically posting agendas for all regular or special meetings of a public body. And obviously the purpose of the agenda is to give advanced public notice of the business of the public body that's going to be considered at the meeting, or of any actions that are proposed to be taken. The statute does provide that items must be added to or deleted from the agenda as the first act of business, but other adjustments like reordering agenda items can be made at any time. Nothing in the statute defines the level of detail that must be contained in an agenda. But I think it would be fair to conclude that the agenda should contain sufficient detail to inform a reasonable person of the business of the public body that's going to be considered at the meeting. And there should be some reasonable nexus between items listed on the agenda and action taken, motions approved or voted on during a meeting. It's not necessary or required to specifically list potential action items on the agenda, but I do think there should be some reasonable connection between items that are listed and votes taken. And, you know, if an issue comes up at a meeting and there has not been reasonable notice through a posted and published agenda, then probably the best practice is to defer that action item until it can be added to an agenda and taken up at some future meeting.
And that's actually, Joe, one of the questions we had. Let me jump down here to the question slides. One of the questions, can a public body vote on an item not on an agenda? I'd say for Joe answered that, one area where I'd say the answer is no is for a special meeting, right? Because for a special meeting, unlike your regular bi-weekly select board meetings, you have to warn the time, the place, and the purpose. So our view of special meetings is that you are very limited to what exactly you've warned in that special meeting. It may not need to say you're going to vote on something, but if you're going to move a vote on subject matter that's not, you know, reasonably disclosed in that special meeting warning, we think you're out of bounds there. And the other thing that goes hand in hand with that, of course, is that unlike regular meeting agendas where you can modify the agenda at the outset of the meeting, we think it's a violation of the open meeting law to add things to a special meeting agenda once you're inside that 24-hour required notice window, it just defeats the purpose of the statute. And, you know, the idea is that folks might want to say, well, that's important to me, I'm going to go to that meeting or not, obviously. So special meetings, you know, have some more stricter criteria. That's what the statute requires, and we think that's pretty straightforward. One of the questions we got was, when are warnings required and when are they not required? And if you consider an agenda a warning, okay, but it's not, a warning and an agenda aren't exactly the same. A warning, again, special meeting, 24 hours minimum before the meeting, posted in the town offices and 2 other regular places, and has to specify time, place, and what's going to be happening. Warnings not required for a regular meeting once it's established that, you know, this board or this council or this committee meets regularly every Tuesday at 7 o'clock, but that's different from, you know, meeting an agenda, obviously. Then there's warnings around things that are hearings. I mean, that's not what we're talking about tonight, but obviously you all know that if you work on the DRB or you are doing a town highway discontinuance or a takings case or something, you know, then you've got notice requirements, which is, again, really not the same as a warning.
And in terms of, and you know, whether a warning is or is not required is maybe not quite the right question. I think the sort of critical issue is whether, you know, the activity that is contemplated constitutes a meeting of a public body. And so if you answer that in the affirmative, then you know whether or not you need to warn, because the warning and posting of agendas, it's not particularly complicated, but the question of whether or not any particular activity is a meeting of a public body, as we've seen, can be quite complicated.
Let's see. So it's 8 o'clock. We've been going a little about an hour and a half. Joe, was there some other parts of our outline that you thought we needed to cover tonight, or did we get through the the regular and special meetings, emergency meetings? I don't know that anybody needs any help with that stuff. Should we check with Rod again to see if there's anyone's got any questions right now?
I do have some questions if Joe's clear.
Go ahead, Rod.
Okay, so this is to do with the DRB specifically. So for all of you who are not on the DRB and therefore endlessly confused and amused by quasi-judicial proceedings, you can take a break now. So this is to do with the DRB. When after deliberation, a decision is approved by a quorum with a minority dissenting, must the decision include that it was not a unanimous decision? I'm not sure if that's actually open meeting law relevant, but.
In other words, does the written decision need to report what the vote was?
Yes.
For DRB specifically. Joe, isn't there a mention of that in chapter 117?
There is actually.
I think there is, yes.
Yeah.
And I believe that there may be circumstances in which a roll call vote is mandated, but honestly, I don't know off the top of my head what the specific answer is, although I do believe that there is a statutory provision that addresses it.
Okay.
Do you want to?
I can look it up if we,
No,
I'll tell you what I'll do is I will get Rod the answer.
That's excellent, because I would like to know, and I think I know the part from 24 VSA anyway, but that just points out I'm kind of a nerd. Okay, so could you go back and give us the citation again for the provision that allows the chair of a public body to set reasonable rules or limitations on public comments at warned public meetings? I think this person here is thinking of.
That's in 1 VSA 312.
Yep.
Subsection H.
Right. Okay.
says, public comment shall be subject to reasonable rules established by the chairperson.
And this could include time limits and the number of times an individual has spoken on a particular topic. Is that correct?
That may be reasonable under particular circumstances.
Right. Okay. All right. I think that covers most of the questions that I've got here. I've been reading them pretty much as they come into the chat box. There's been some other commentary as well, which has been captured, but if you've got some things that you want to cover, Joe and John, before we wind it up, that sounds good to me.
Joe, I think we're going to, again, this PowerPoint's got quite a bit more material in it, but a lot of it's just the mechanics of different parts that are pretty straightforward, and that most of the time boards, councils, committees don't really have trouble navigating. You know, my feeling would be if Herb and Rod feel like we've covered enough material for tonight, unless there's any more questions that someone wants to say, gee, I wish you guys had talked about this or that. You know, could maybe give it another minute or two for that. But Joe, anything else pressing you think we really ought to get into?
You know, I don't think so. I think, you know, it's there's a lot of ground to cover. We could probably have done 3 hours of this, but the what I would just like to say is that there were a number of board or committee members, commission members who forwarded specific questions to Herb. And for the purposes of this presentation, we've tried to consolidate some of those questions in our comments, because there was a little bit of repetition in terms of the themes. But we did specifically attempt to answer each question in written format, and we will include that information in the material that we provide to Rod and Herb. So if you submitted a question and it hasn't been addressed specifically tonight, it may be addressed in writing in these materials. It should be addressed in writing if you submitted one. And if there are other questions that have not been addressed, get them to Rob and or to Rod or Herb, and you know, we will make an effort to you know, get some information back.
I have two more quick things I could add. One is that you know, there was some discussion around drafting documents and preparation, and again, our bottom line is that, you know, if there's a quorum of your board or your committee, then yeah, document work ought to be happening in an open meeting. One thing that folks lose sight of, and it wasn't probably clear until the Vermont Supreme Court decided this some 12 or 15 years ago or something, is that just because a document which is exempt from disclosure under the Public Record Act is considered in an open meeting does not decide whether or not it loses its exempt status. So, you know, it's a funky situation. You could be there having a conversation about a document, maybe something you're writing together as a group, and maybe that document has some grounds to be exempt under the Public Records Act. The fact that it's considered in an open meeting. So for instance, let's say you do a written reprimand letter to an employee, and there's an argument to be made that the content of the letter qualifies for a Public Records Act exemption. Well, you have to vote out a written reprimand letter in an open meeting because it's an action of the board. Just the fact that you do that and that document's there on the table in front of all the board members doesn't mean the public gets to look at it, for one thing, and it also doesn't mean that it's waived Public Records Act exempt status if it had it to begin with. Not all personnel documents are automatically exempt. They're not automatically exempt, period, except for certain limited kinds. The last thing maybe I thought would be good to end up on is we got one question. I'll just run down to it here on the board, which I thought's an interesting question. And it was well, there were a couple of questions around sort of practical issues and application. How do you apply the statute in real life, and how do you deal with some of these things? And you know, I thought that these bullets are all pretty interesting. You know, the second one, what if the statute has negative effects of impeding progress, overloading staff, discouraging community volunteers? How do we balance the goals of the statute with, you know, things being done in a reasonable time and having efficiencies? And it's a great question. The answer is, part of the answer is, these are legislative decisions that have been made and adopted into statute. And so you really have no choice but to comply. And if that means that, you know, there's some inefficiency and difficulty and, you know, extra challenges that you don't think are reasonable, or what you have to face is working as part of a town board. It goes with the territory. You know, we deal with boards a lot in meetings, and you know, so we see this on a frequent basis in our work. And yeah, it can be extremely frustrating. But you know, the legislature has made the policy choices here to say that there's these lines, and that once you cross the threshold from one end to the other, you really got no choice but to comply. So yeah, it might be discouraging to volunteers, and you know, this is not legal advice per se, but you know, people who are coming into positions ought to come into it with their eyes open, you know, to the fact that it could be rigorous, and it's not so easy sometimes to do the work of the board when they want to volunteer and help out, you know, because you're going to have to really make sure you're complying with these things. And you put the town in you put the town in some jeopardy if you fail to do it. And you also don't want to run afoul of the purpose of the statute, which is to give the public a chance to see how its government is operating and be involved and be knowledgeable and have a chance to participate. So when you say how do you balance the purpose of the statute with time and efficiency, probably the more you know about the statute, the better chance you're going to have to be successful in that. You know, because it's boards and commissions and committees that are probably inadvertently, hopefully, I don't think anybody's going to purposefully run afoul of the open meeting law. You're just making matters worse, right? Because some vote you think you passed 6 months ago, and now you're off and running and pursuing financing or something. You know, if it wasn't conducted in compliance with the open meeting law, the whole thing may be voidable or void. And so we don't have great silver bullet answers other than to say, be knowledgeable about it, be more conservative when you're in doubt, call your attorneys if we can, you know, these are things usually we don't have to spend hours and hours dealing with when we get these kinds of questions. We've been around the block with enough of this stuff that we can usually have a pretty quick answer. Again, we don't have all the answers, but you know, we're there for you, and we're empathetic that yeah, it's not easy to make sure that you're always going to try to not try. You're going to be doing what you need to be in compliance with the open meeting law.
Okay, if I have time for just one really quick question that I think can be clarified really quickly. So I think it was from somebody from the listener's office again, wanting to know whether when you notice a meeting by circulating the agenda, do you also need to include the meeting packet with all the documents that are going to be discussed in that meeting, or can you just post the agenda?
Joe, correct me if I'm wrong, there's no, okay, I don't know about the listers if there's something specific for them, but the open meeting law does not have a packet, you know, pre-meeting requirement in it.
That's my understanding.
Right.
It's definitely a practice that a lot of boards follow, right. And it's, you know, again, you're talking about efficiency and things like that, but
right. There may be, you know, of course, the open meeting law contains any number of requirements. There may be, as John mentioned, things that are done as a matter of municipal practice for convenience or efficiency that just makes sense, even if they're not required. And, you can evaluate whether or not you think, including the meeting packet with agendas is something that is valuable to advance the meeting or not. But I don't think the open meeting law requires it.
Right. Yeah, my understanding is that you just need an agenda. Setting aside the question of whether people are going to be annoyed about whether they don't know what you're talking about. Okay. Okay. I think we've reached the end in more ways than one. Thank you very much, Joe. Thank you very much, John and Herb. Thank you, everybody, for joining. Unless there's any quick comments or observations from either Joe or John, I'm going to click the red button and you're all going to go away.
I just want to say thank you. It's been a pleasure to speak with you all tonight.
I agree. Thank you very much. And if we can assist anyone with follow-up, please let us know.
Thanks very much. Thank you very much for joining us, both John and Joe. Thank you.
Thank you. Thank you all.
Okay.